Hello and welcome back. In our first episode, you remember we treated the tort of battery, which states that you need to establish 6 elements in order to be successful in an action of battery. These elements, as we discussed, were the directness of the act, the voluntariness, physical contact, state of mind of the actor. It needs to be a positive act and not an omission to act, and the lack of consent. Now, in this episode, we will deal with assault. We will deal with the elements of assault and other important points to note. We are going to identify the elements of the tort of assault. And we are going to highlight the major principles you would need when explaining these elements. They will also help you to appreciate how these principles are applied accordingly. To begin with, what is the tort of assault? At common law, assault is a tort of acting intentionally. That is, with either general or specific intent, causing the reasonable apprehension of an immediate or imminent harm or offensive contact. Actual ability to carry out the apprehended contact is not necessary. Thus, an actionable assault requires that a defendant intends that the claimant apprehends the application of unlawful physical contact, that the claimant reasonably apprehends the immediate or direct application of unlawful physical contact, and that the defendant has no lawful justification or excuse. Now, what are the elements of the tort of assault? First, all elements of battery are found to be in existence in the tort of assault except for the element of physical contact. Aside from them, the specific elements of assault are 1. Positive act by the defendant. 2. The plaintiff had reasonable apprehension. 3. The requisite state of mind of immediate or imminent physical contact. 4. The defendant's act of interference was intentional, or the defendant intended the resulting apprehension. You can see Collins versus Wilcock for the above mentioned elements. Now to some explanations. 1. Positive act by the defendant, incapacity, ability, or possibility on the part of the defendant. We must note that there is no assault where there is no capacity to carry out the act threatened. This was held by Scott J. in Thomas versus National Union of Mine Workers. Also, assault does not lie where there is no means of carrying into effect the threatened act. This was held by Tyndall C.J. in Stevens versus Myers. Also, assault lies where there is an intention to assault and also the ability to carry the threat into execution. Assault lies where there is an intention to assault and also the ability to carry out the threat into execution. This is held by Jervis C.J. in Reed versus Coker. For a threat to amount to assault, there also must be an intention to carry out the threat into effect. If it was impossible at the time to carry out the threat, there is no assault. This was held by Lord Abringer CB in Blake versus Bernard. Also, the plaintiff had reasonable apprehension. Under this, for an action in assault to lie, the plaintiff must prove that he apprehended fear or that he had reason to apprehend fear and that the defendant was, under the circumstances, going to carry into effect the threatened act. This was held by Jack J. in Darwish versus Egypt Air Limited. Again, Where a person reasonably believes that he is in fact in danger of violence, actual intent or power of the defendant to carry the threat to its effect may not be necessary. This is held by Ferguson J. in Bruce versus Dyer. The time to start measuring the immediacy of the apprehended violence is the time when the victim has the fear, and it is enough to prove that the victim had the fear. The medium through which he has that fear is irrelevant. This was held by Scheiman L.J. and R.V. Constanza. Also, still under elements, the requisite state of mind of immediate or imminent physical contact can refer to Stevens versus Myers. Under this, assault requires an apprehension by the plaintiff that he is about to be struck. A failure of battery without such apprehension, there is no assault. This was held by Justice Keith in Regina versus Nelson. Also, another element is the defendant's act of interference was intentional, or the defendant intended the resulting apprehension. You can see Jervis C.J. statement in Reed versus Cooker, and then Lord Abinger C.V. in Blake versus Bernard, already highlighted under the first element. With intention, mere words do not amount to assault, as stated by Holwell J. in R versus Mead and Belt. But in R versus Wilson, Goddard C.J. clarified that mere words could constitute assault, provided the state of mind could be established. However, Tuberville versus Savage, the principle on spoken words was summoned on the words negating an intent to carry out a threat makes the threat no assault. That is, the principle on spoken words was summed up that words negating an intent to carry out a threat makes the threat no assault. As said, the intention to assault could be either general or specific. Specific intent means that when the defendant acted, he or she intended to cause apprehension of a harmful or unwanted contact, whereas general intent means that the defendant knew with substantial certainty that the action would put someone in apprehension of a harmful or unwanted contact. Contact under assault simply could mean harmful if it be objectively intends to injure, disfigure, impair, or cause pain. The act deemed offensive if it would offend a reasonable person's sense of personal dignity, while eminence is judged objectively and varies on the facts, and generally suggests that there is little to no opportunity for intervening acts. Also, apprehension requires that the person be aware of the imminence of the harmful or offensive act. Any questions can be written in the comments. Don't forget to like, subscribe, and share this particular video.